All right. Um, Hello, everyone. My name is Michael Pereira. I'm an attorney here with Herzl Law. Thank you, everyone, for coming and joining me for tonight's webinar, Reefer Madness, How to Address Marijuana Issues in Your Association. So tonight we're going to address common marijuana issues and how to fully address them, or hopefully fully address them. And if I can get this going, there we go. All right, so we're going to address 5 major topics tonight. The first topic is going to be a brief overview of the legal status of marijuana on both a federal and state level. We're going to touch on some medical and recreational uses for marijuana, common issues that we see in community associations, different enforcement mechanisms for how community associations can address marijuana. And then finally, we're going to end the night talking about how associations can amend their documents to more fully or better address common marijuana problems. And before I get started, if you have any questions, we will have time at the very end to address those questions. So please, if you can, try to hold your questions until the end. But if you do have a burning question, feel free to either raise your hand, and if I see you, I will try to stop and address your question. And if need be, we can go back to any kind of slides that can address your question at that time. So moving forward, federal legality. Marijuana, whether you spell it with a J or an H, is a Schedule I drug under the Federal Controlled Substance Act, which makes the use, cultivation, and possession of marijuana illegal under federal law. Schedule I drug means that the federal government considers that marijuana has a high potential for abuse, has no currently accepted medical use in treatment, and there is a lack of accepted safety for use of marijuana under medical supervision. So what this pretty much means is that according to the federal government, marijuana is completely illegal. There is no redeeming qualities for it, even in a medical setting. The Controlled Substance Act provides for civil and criminal penalties for the use, cultivation, and or possession of marijuana. The criminal penalties for violating the act includes a maximum prison term of 20 years and or a fine of up to $2 million. And then the civil penalties likewise have a maximum penalty of either greater than $250,000 or twice the gross receipts that were derived from each violation attributable to the person. That second provision is unlikely to apply in community association settings. It's more geared towards producers of marijuana or dealers of marijuana, although there could theoretically, that could theoretically apply for associations if they received money that was derived from marijuana illegal activities. But from my point of view, the civil penalty that would most likely be incurred would be just the up to $250,000 fine. In Michigan, as you likely know, on November 6th, 2018, 2,356,422 Michiganders voted to approve Proposal 18-1, which was later codified as the Michigan Regulation and Taxation of Marijuana Act. Again, marijuana with an H. Not that that matters, just going to point it out. Broadly speaking, the MRTMA decriminalizes the possession, use, consumption, and cultivation of marijuana by those who are 21 years of age or older. And so just a quick note here about terminology. The MRTMA does not legalize marijuana. Instead, the statute decriminalizes marijuana by preventing the arrest and penalties for the possession, use, consumption, and cultivation of marijuana, as long as you are complying with the statute. For example, if you smoke marijuana and then get behind the wheel of a car, that is still illegal, and it is still a criminal offense. Just like there are certain numbers restrictions and weight restrictions for possessing marijuana as well. And so as long as you are complying with the terms of the act, there are no criminal penalties that can be imposed on a state level. And the reason for explaining this terminology distinction between decriminalization and legalizing is because of the supremacy clause in the United States Constitution, which states that the US Constitution and federal laws trump state laws, and that no state may enact any law that is contrary to the Constitution or federal law. So like I mentioned a slide ago, that under the Controlled Substance Act, marijuana is a Schedule I drug and is fully illegal. No state can make marijuana legal. And so the way that states get around the supremacy clause is by just removing criminal penalties for compliance with the terms of the act. And so while it might be common to say that marijuana is legal, and indeed, I think in a couple slides in this webinar references marijuana being legal, just keep in mind that there is a distinction between decriminalization and full legality of marijuana. So with those two in mind, let's just jump right into a hypothetical. So Sally Stone's favorite pastime is to pass the time by smoking marijuana in her condominium unit. The odor has become an annoyance to her neighbor, Sergeant Buzzkill, who reports Sally's marijuana use to the condominium association. The association sends Sally a letter requesting that she stop smoking in her unit. Sally claims that the association cannot stop her from smoking marijuana because it is legal/decriminalized in Michigan. Can the association restrict Sally's marijuana use? Feel free to type your answers in the chat, or you can also unmute yourself to give me a verbal yes or no, and just remember to mute yourself at the end so we don't have any interruptions in the presentation. One answer, yes, if private community based on federal law. Couple no's. So those are some good reasoning based on your answers. And so let's find out. The answer is yes, an association can restrict marijuana use, and one not sure. So the MRTMA allows a person, and a person is defined by the act to include a corporation, which most community associations are corporations. So a person can regulate or prohibit marijuana-related activities on property that the person or association owns or manages. So putting these two provisions together, yes, an association can restrict marijuana use under the MRTMA, as well as potentially under federal law, by saying that under federal law, marijuana is still illegal, and so the association could restrict it in that instance as well. But speaking purely under Michigan law, Yes, an association can prohibit or restrict owners in the association from using marijuana. All right, so let's change it up a little bit. We were talking, the MRTMA concerns recreational marijuana. So now let's transfer over to medical marijuana and medical issues. The association is receiving numerous complaints about an owner, Miss Ima Puff, smoking marijuana in her unit and on her balcony. The association has asked Ima to stop smoking. Ima claims that she has a disability and requests a reasonable accommodation under the Fair Housing Act to continue smoking. Must the association allow Ima to smoke marijuana in her unit and on her balcony? So what does everyone think? Yes, no, not sure, it depends. So we have 2 no's. One of those no's says there must be some accommodation. And we have 1 yes, another no. So again, the room is divided. So let's find out. Medical marijuana. The Fair Housing Act carves out marijuana use in defining whether a person is handicapped or disabled under the statute. The statute specifically says that handicap means a person who is regarded as having such an impairment that substantially limits one or more of the person's major life activities, but does not include current illegal use of or addiction to a controlled substance, which marijuana is a controlled substance. And so that excludes illegal drug users from the definition of disabled individuals or handicapped, such that there is no fair housing coverage. And in addition to that carve out in the definition, federal courts have also weighed in on the issue and held that marijuana use is not a reasonable accommodation because authorizing a disabled individual to violate federal law is not reasonable. So under the Fair Housing Act, if a person qualifies as disabled, the association would be required to make an accommodation for that person that is reasonable and necessary. And again, violating federal law is not reasonable. Okay, so let's move on to common issues in associations. Now that we have an understanding of the legal status of marijuana on a federal and state level and have a little bit of a primer on recreational and medical issues for marijuana, let's get into specific examples. Another hypothetical, we're just diving right in. So the association's governing documents prohibit illegal activity in the community as well as nuisances. An owner, Mr. Inhale, smokes marijuana in his unit and the association has received complaints. When the association sends a violation letter, Inhale argues he is entitled to smoke marijuana under state law and there is nothing the association can do about it. Is this correct? Can the association enforce its governing the provisions in the governing documents against Mr. Inhale? So the chat has 1 yes, 2 yeses. Okay, so this one, this hypothetical, I tried to highlight the nuisance provision. So most community associations have a restriction in their documents that prohibit nuisances, and a typical nuisance provision is on the screen, such that no illegal or offensive activities may be carried on in any unit or on the common elements, limited or general, such as a balcony, nor may anything may be done which may be or become an annoyance or nuisance to the co-owners. So in regard to nuisance provisions specifically, litigating these issues is highly fact specific because courts have come to opposite decisions regarding whether secondhand smoke, specifically in the context of cigarettes, is a nuisance to other owners. There hasn't yet been any cases specifically addressing secondhand marijuana smoke, although with the recent decriminalization in Michigan, I'm sure that those kind of cases are in the pipeline. An example of the split in courts about secondhand cigarette smoke, there was a court in Washington, D.C. that issued an injunction prohibiting an owner from smoking cigarettes, cigars, and marijuana in their home because the smoke went into the neighbor's home. If I'm remembering correctly, even though marijuana was addressed in the opinion, it wasn't part of the facts. I believe that the smoke at issue was cigarette and tobacco smoke, but the court also included marijuana smoke in there as well. The other side to that is that a Michigan federal court found that there was not sufficient evidence to establish that the extent or the amount of secondhand smoke created a nuisance in this particular case, or that the smoke harmed the other owners. So again, litigating a nuisance provision is just going to be highly fact specific. That really just depends on the facts of the case, in addition to the judge that is hearing the case. There's a question in the chat. What if the second hander does not smoke marijuana and takes a drug test and results are positive due to the neighbor's smoke? Yeah, that is certainly wild and definitely possible. I don't necessarily think that that fact scenario would lead to a nuisance violation, although it definitely could be. Again, highly fact specific, and hopefully that would not happen. That could cause negative repercussions to the neighboring co-owner's life for a positive drug test, just because their neighbor decides to smoke some marijuana. Another question is, if there is an underlying health condition with the person being annoyed, so the secondhand smoker, does that hold weight with the courts? Absolutely. I think that would just go into whether this particular person is suffering a nuisance because under the sample nuisance provision, it is this specific co-owner is highly sensitive to the smoke, and that is creating a nuisance. Whether that would be outcome determinative in the court, that's anyone's guess. But I think that those kind of specific inquiries and different subjective needs of the person, those are definitely relevant for any kind of enforcement actions. Good question, Lee. All right, so let's move on to our next hypothetical. So Sally Stone's favorite pastime is to pass the time by smoking marijuana in her condominium unit. The odor has become an annoyance to her neighbor, Sergeant Buzzkill, who reports Sally's marijuana use to the association. The association sends Sally a letter requesting that she stop smoking. Sally claims that the association cannot stop her from smoking marijuana because it is legal / decriminalized in Michigan. Can the association restrict Sally's marijuana use? And I think I hinted to the answer for this question earlier. So I'm just gonna go ahead and go on to the answer. So for the previous question, it's going to be a very similar provision. Typically, illegal and nuisance activities are addressed in the same bylaw provision. And so the answer is yes. Even though marijuana is decriminalized under Michigan law, it's still illegal under federal law, and the association can seek to enforce the federal legal status of marijuana as a basis to say that Sally is violating the law. All right, let's now transition to the world of insurance, everyone's favorite topic. Miss Green Thumb grows 12 marijuana plants for personal consumption. Green plugs in 12 grow lamps into the same outlet and burns her condominium building down that has a replacement value of $1 million. The association did not know about Green's agricultural activities. Does the association's insurance carrier have to provide coverage? Yes, no, maybe. One vote for yes. One vote for no. Two votes for no. So the answer is going to be fact specific depending on the terms of her of the association's insurance policy, but it's probably not. In my experience, most insurance policies have a criminal act exclusion that allows insurance carriers to deny coverage for criminal activities. This was borne out in a federal case from the Sixth Circuit, where that Michigan is in the Sixth Circuit, KVG Properties versus Westfield Insurance. And in that case, the plaintiff, KVG Properties, rented out their commercial property to some tenants, unbeknownst to the landlord plaintiff. The tenants operated a marijuana grow facility in the commercial property and caused this huge fire. And by the time, or I believe, no, it wasn't fire. It was just damage to the property. And so the plaintiff submitted a claim to their insurance carrier, and the insurance carrier denied coverage because of the criminal activities. One basis of it was that marijuana is illegal under federal law, and also because these tenants were not complying with Michigan law at the time. So on both bases of Michigan and federal law, these tenants' activities were illegal. So, and the court affirms the denial of coverage. So a similar hypothetical where Miss Green Thumb burns down her condominium building because of her 12 grow lamps. But in this hypothetical, Ms. Green obtained permission from the association to grow the plants, but the association did not disclose her activities to its insurance carrier. Does the insurance carrier have to provide coverage? And so for this hypothetical, this slight change in the facts, let's ignore the legal versus the criminal acts exclusion. So we have one vote for no, two votes for no. So this one's a little tricky. This one is you either read too many insurance policies or you're just making some good guesses. So another somewhat typical insurance provision could be a change in use or occupancy provision. So in Nationwide Mutual versus McDermott, the federal court considered a case where very similar to our hypothetical, where there was a residential property that had been, I guess, sort of transformed and was using the residential property for commercial marijuana production. And under the terms of the insurance policy, the defendant had a duty to notify the carrier of any changes of use to the property. The defendant did not notify his insurance carrier that the building was being used for a marijuana operation, and the insurance carrier denied coverage. And the Sixth Circuit again upheld that denial. Okay, so the association's utility bills are skyrocketing, especially water and electricity. There's a suspicion that an owner, Mr. L. Ike Puffing, is growing marijuana out of his home, and it appears that the increased utility charges were caused by him. Does the association have a remedy against L. Ike Puffing for the excessive water and electricity use? What does everyone think? Yes? No? Maybe? All right, we had a couple quick yeses, so people are pretty confident in their answers this time. So the answer is, like all good lawyers, it depends. It is possible to charge the utilities back to L. Ike Puffing if the association's documents allow the assessment of excessive expenses back to an offending owner. So in this situation, the association's documents would have to have an assessment provision that would allow excessive uses or excessive charges that the association has incurred to be able to assess those charges back to Mr. Puffing. A couple issues that may arise if the association has that type of provision is how to calculate the excess amount and how to prove it. So proving it would have to most likely demonstrate that Mr. Puffing was indeed growing marijuana and that he was the sole contributor to these excessive utility bills. And calculating that excess amount would likely require a little bit of backwards looking, where, for example, let's say that the association had electricity and water bills that were fairly constant throughout history. And then all of a sudden, Mr. Puffing, the association can pinpoint the day where he started growing marijuana, and they started seeing the utility bills increase. In that situation, the association would likely be able to figure out the exact dollar amount by comparing the current and historical utility charges and being able to pinpoint that these charges were incurred because of Mr. Puffing. It gets a little bit more complicated if there are multiple owners who are using excessive utilities, but for the purpose of this hypothetical, yes, the association can assess the excessive utility charges back to Mr. Puffing because they have a provision that allows it. They can pinpoint that Mr. Puffing was the one who is responsible for it, and they know the dollar amount that has the excessive dollar amount represents. Okay, so there has been an uptick in vehicle traffic going to and coming from Dave Dealer's unit. One of Mr. Dealer's neighbors has noticed that he hands a package to the visitors, who then hands, Mr. Dealer a bundle of money. When asked, Mr. Dealer states that he is running a fully legal and licensed marijuana dispensary from his unit. The association wants Mr. Dealer to stop, but he claims that he is allowed to continue selling marijuana because he is fully licensed. Can the association prohibit Mr. Dealer from continuing his fully legal and licensed dispensary? So Curtis and Tracy say yes. Gail, I just saw your question and we'll circle back to that at the end. If I don't remember, please remind me. So Curtis says yes, Lee says yes. So the answer is most likely going to be yes. And again, as Lee highlighted, it depends as to what the bylaws say. So Mr. Dealer's activities in running a dispensary out of his unit would be a commercial use. Typically, we see that bylaws have one of two, if not both, provisions either requiring that units be used for residential use only, and because he is using his unit for his business, that is not a residential use and would be prohibited. The flip side to that coin is prohibiting business or commercial activities. And obviously, because he is running a dispensary, that is a business or commercial activity that the association could seek to prohibit. The third option is zoning issues, and this is going to be dependent based on the local unit of government where the association is. Sometimes zoning issues can arise where an association is in a zone that is only a residential zone, and the zoning ordinances specifically prohibit commercial or business activities from occurring in residential areas. So that could be one way that the association could seek to enforce it. Another zoning issue is if that the ordinances don't specifically prohibit commercial activities from occurring in residential zones, the zoning ordinance may say that only certain types of business activities can occur in business zoned areas. So there are three ways that the association can prohibit Mr. Dealer from operating his dispensary in the association. Okay, so let's, instead of focusing more on the reactive side for association enforcement, let's talk a little bit about how associations can be proactive in prohibiting marijuana usage. And one way to do that is to amend your documents. Possible options for prohibiting marijuana through a document amendment would be to explicitly ban marijuana usage, possession, or consumption in the within the association's property could be specifically prohibited. Alternatively, the association could seek to ban all forms of smoking, whether that's cigarette smoke, cigar smoke, vaping, or marijuana smoke. And a third option is to prohibit illegal activities. As we've seen from a couple of the prior hypothetical situations, associations typically already prohibit illegal activities, although not always. And so that could be one way that the association could seek to prohibit marijuana, is to prohibit illegal activities. And the positive for having an illegal activity provision in your documents is that it addresses more situations than just marijuana specifically. But again, associations typically already have illegal activity prohibitions in their documents, so that might not necessarily be an avenue that most associations would have to take to amend their documents. So there's a question on this specifically to, should we add language for both local, state, and federal? That's definitely an option. Specificity is not necessarily a bad thing, but by prohibiting illegal activities, that general prohibition for illegal activities should be allowed to encompass local, state, and federal laws. So can you be specific? Yes. Do you necessarily have to? I don't think it's necessary, but it's not a bad thing. And if you are looking to amend your documents to include this illegal activity prohibition, that would be something to talk with your attorney about, or just to have a discussion amongst the board with. And with that, we have reached the end of what I have prepared. So if you have any questions, I would love to answer them. So you can feel free to unmute yourself at this point. You can ask them through your speakers. We don't have to keep going through the chat. Although if you do want to use the chat, I'm more than happy to read the questions out for the group. So we have one question from Curtis and Tracy. How do we send a violation without seeing the activity? So that's a good question. And that goes to an issue that we see a lot, where there is an assumption that something is happening because a neighbor walks by a unit and smells, something off, and they assume that it's marijuana, and sometimes it is and sometimes it's not. So having direct evidence of the violation is certainly helpful, but it's not, if there is a reasonable basis for the association to believe that a violation has occurred, that should be enough to at least send a demand letter to the owner saying that the association reasonably believes X, in the context of this webinar, reasonably believes that you're smoking marijuana in your unit. Here's why the association believes it. A board member was walking by and smelled burnt marijuana coming from your unit. Here are the provisions you're violating. Please stop. So in that instance, the more evidence that you can have of a violation, the stronger the demand letter can be.
Oh, okay. Can I ask? I have my hand up. I don't know. Well, can I first say thank you, because we've been grappling with this, and this is the most thorough information that we have been able to obtain. And it just shows that Herzl Law is continuing to explore this and keep up with the latest of what's happening to give us more information that is more helpful. And I can only tell you this is extremely helpful. So to your point, we had a few issues, and we do know that grow lights are pink. And typically grow lights are an indication that something's growing inside of a unit. And we can't assume it, because we had the opportunity we had to go into one of these units with the pink light, only to see that they were growing herbs and vegetables and things. And some of them weren't even surviving. So that's that. But then the other part is when you see a black window, a window that's covered to keep the light out, but some of that pink is visible, that's a different kind of an issue. Because as we understand it, that's when it's typically marijuana growth. But then we address the window covering as opposed to the marijuana growth. Does that make any sense?
Yeah. So in that situation, I think that yes, the covering the window is an unnatural occurrence that might give rise to a reasonable basis to believe that something is going on in the unit that the owner does not want other people to see. And it could be a perfectly reasonable explanation for it. Maybe they're a third shift worker who just needs to get some shut-eye during the bright hours of the day. And in that instance, what I would probably recommend is writing a letter to the owner saying that, hey, here's what we've seen. You're blocking out your windows. That in and of itself may be a bylaw violation, depending on the specific provisions in the bylaws. And so, please take that down. And if you can kind of see that little different colored light coming out, that would also be something to address. And so even if you're not seeing the grow lights shining on marijuana plants through the window, those kind of other indications could be the basis for a violation letter. Absolutely. And thank you very much for what you said about the presentation. I know that myself, in the past couple months, I've been getting a lot more clients coming to me with marijuana issues. And so we as a firm have definitely seen the uptick in marijuana issues in communities. And so we did feel that it is important to address that to our clients. And so thank you for the kind words.
You're welcome. Again, thank you. Can I talk about one more recommendation? Because I just spoke with Herzl within the last 2 days. Mm-hmm. And with the insurance issue, that's going to be our approach because we have multi-dwelling units. And the concern was whether or not insurance would cover an issue or damage if it was a result of marijuana growth. So now we know concretely that there is an answer to that. And our insurance agent has also told us that insurance companies are moving away from even covering a dwelling, issuing policies if they know marijuana growth is occurring. Mm-hmm. And then to your point, if they don't disclose, they won't cover them. So this all comes to a nice, neat package, if you will, in that it puts everyone at risk. And so we have to address it.
Yeah, absolutely. And if you have any questions about how marijuana use, cultivation, possession could affect your association's potential coverage in the event of a loss, bring that up to your insurance agent. They would be the ones who would be able to take a look at your insurance policy specifically and give you some guidance, or just give you their thoughts as to how their coverage typically handles or addresses marijuana related losses. I'm going to go out on a limb and say, based on the two cases that I covered, they would probably not cover any kind of damage caused from marijuana. So that is definitely one reason to stay on top of growing and cultivating marijuana specifically.
Thank you.
Thank you. And I want to go back to the question that Gail raised during the utilities. So Gail asked, would the utility charges have to be in the bylaws, or would rules be sufficient? So for that, I believe what you're asking is if the chargeback provision that would allow the association to charge back or assess excessive utility use back to an owner, that would most likely be, that should be in the bylaws as opposed to a rule and regulation. To be safe, if it's in the bylaws, it would be effective. If it's going to be in the rules and regulations, that's when issues can arise as to whether it's a proper exercise of the board's authority to adopt rules and regulations. And so in my mind, it's better to be safe and sorry and include that in a bylaw amendment if your bylaws do not already contain that type of provision.
Thank you.
Okay. Do we have any other questions? I don't see any in the chat. All right, well, hearing no questions, I'm going to end this webinar. It's been just shy of an hour. So thank you all for coming. If you do have any questions, my contact information is on the screen. And please feel free to either give me a call and we can discuss some questions more specifically, or feel free to write me an email and I will get back to you for those questions as well. So again, thank you all for coming. Thank you for asking the questions. Thank you for being great listeners. And I hope to see you all soon and hear from you. And have a good night, everyone.